Hello everyone, this is Shiv, Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of India. So in the today's session, I am dealing with defense of intoxication, where in the first session I had dealt with the general exceptions given in IPC, and further I had gone through the section 85 of the IPC and for its principles and a basic case of rape case, where it was seen that the defense of voluntarily intoxication was not given. So, coming to section 86 of Indian Penal Code 1860, which deals with the offence requiring a particular intent or knowledge committed by one who is intoxicated. Section 86 simply deals with that classes of cases where a man gets intoxicated voluntarily. It imputes the same knowledge to such a man as he would have been intoxicated, that is, the knowledge of a sober man with regard to the consequences of his acts. Section 86 deals with the intoxication which is self-induced, that is voluntarily. Such intoxication which results in an offence follows the principle that one who sins when drunk be punished when he is sober. For example, if a person who has consumed too much liquor takes a knife from his house and goes with the intention to kill a person but instead kills a person who tried to pacify him, his acts could amount to murder once he is sober. In the case of Basudev versus the state of Peshpo, the law of drunkenness has been very nicely summarized. Very nicely. The appellant, Basudev of the village Harigad, was a retired military Jamadar. He was charged with the murder of a young boy named Maghar Singh, aged about 15 or 16 years old. The two of them and others of the same village went to attend a wedding in another village. All of them went to the house of the bride to have a midday meal. Some had settled down in their seats and some had not. The appellant asked Maghar Singh, the young boy, to step aside a little so that he might occupy a convenient seat. But Maghar Singh did not move. The appellant wiped out a pistol and shot the boy in the abdomen. The injury proved fatal. While rejecting the plea of the accused to allow him the benefit of section 86 and reduce the charge from murder to culpable homicide not amounting to murder, the Supreme Court laid down some rules for the guidance, like the absence of understanding of the nature and the consequences of an act, whether produced by drunkenness or otherwise, is not a defense to the crime charged. The evidence of drunkenness, which renders the accused incapable of forming the specific intent essential to constitute the crime, should be taken into consideration with other proven facts in order to determine whether or not he had this intent. The evidence of drunkenness falling short of a proved incapacity in the accused to form the intent necessary to constitute the crime, and merely establishing that his mind was affected by drink so that he more readily gave way to some violent passion does not refute the presumption that a man intends the natural consequences of his acts. So, it can be said that intoxication is a very strong defense, and even if it serves to migrate the severity of a punishment, it cannot exculpate the person from liability. This is essential because absolute or cold logic cannot be applied to human affairs, as they require certain flexibility in their dealing. A common man will not have much regard for the law if a drunken man batters him, and the man gets away with his conduct merely because he was too intoxicated to think clearly. In India as well, the law that has been followed till date has its foundation in British law. The first categorical difference is that in the case of British law, the defense of intoxication is not codified under any specific section, while under the Indian law, it has been clearly codified in sections 85 and 86 of the Indian Penal Code. In Indian law, the clause that the drug has to be administered against the will of the individual is given, which with much more importance than it is under the British law. Also, the dichotomy between the specific intent and the basic intent is given a lot of importance in the case of British law. The severity of punishment of an individual can be given is reduced due to this. In Indian law, as well as this exception is applicable, as well as the exception in the case of individuals who mind disease, the portion of the law is very similar to British law. As a matter of fact, the cases that have been cited as authority are also British. The second factor that can be considered in the case is that in the Indian criminal law, the difference has been made very clear between the intention and knowledge of an individual. Even in British law, the specific intent and the basic intent dichotomy has been elaborated, but they have not given an exclusive difference between the knowledge and intent. The English law has evolved a series of cases, and it has become a long way from the rigid law that it was earlier. In the early 19th century, alcohol would never have been able to serve as a defense. Rather, it would have a reverse effect and this shows us how much the law has progressed in this aspect over a period of time. That's all for now. Let us meet in the other session. Thanks for watching. Please do like and subscribe the channel. Thank you.